Right, we're on the record. This is People Said Michigan versus Parnell Michael McCreary. 2356485. Mr. McCreary is charged with count 1 assault, attempted murder, count 2 assault, to be written by the crime less than murder or by strangulation. Count 3 weapons, firearms, possession by felon. Count 4 weapons, ammunition, possession by felon. Count 5 assault with dangerous weapons, felonious assault. Count 6, 7, 8, 9, 10 weapons, firing firearms, visual offender, 4th offense set for a hearing today. Appearances.
Edwin Milwaukee, P54828, appearing on behalf of the people.
And Lauren Yerkesian on behalf of the people, P67.04.
Parnell Michael McCreary, Gill, on lowercase, natural person, not a person. If I may ask this court a question, address the court.
Well, the appearances first.
And good afternoon, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, as the standby attorney.
What's your question?
First, I would like to object, no disrespect to Esquire here, but he does not represent me.
I know that.
Okay. Yes, but the prosecution.
Objection has been noted on the record.
And the
You have a
prosecution and them are.
You have a question?
Yes.
What's the question?
I didn't know that the court would allow the prosecution to commit felonies in violation of state and federal law.
That's not a question, that's a statement. Okay, so we have appearances
Also,
on the record.
the question
You're
is.
not gonna talk over me today.
All right.
So we have Attorney Washington as standby counsel. He does not represent you, but in the event that you need help, he's there to help. This is your request that we're on here today, so you can begin with your request to report.
I don't, he's not representing me.
We've already established
Yes.
that. So you can begin.
Yes.
I have your documentation here, so you can start.
I haven't had anything from the prosecutor's office. You gave the prosecution 2 orders to give me discovery under People versus Davey, the 225 Michigan Appeals 592. Violation of a discovery order is grounds for dismissal. Also, I would like that the court, as well as the people, provide their bond numbers, their licenses to practice law. Yes, and their oath of office. Because right now at this point, I'm being violated. I would like to also have Kim Worthy here, the chief prosecutor, because she has committed crimes past and present. I would like a change of venue because DPD has been continuously retaliating over years. It's well documented. People have been lying, making false complaints. They're usually known perjurers. I've made reports with Detroit police, and I'm not being given the same rights as any other citizen. A person is being called in, and they're saying, well, hey, Mr. McCreary did this and did that. They come to my house. They bang on my door. They're impeding upon my freedoms, my sovereignty. They're a corporation. Corporations cannot act upon natural persons. Now, the case of Coins versus Virginia, 19 U.S. page 264, says that it started in D.C. They incorporated the inhabitants of D.C. and the states, other states. I am not a corporation. As I stated numerously in the beginning of this case, ab initio, I reserve my rights not to be compelled to perform under any contract or commercial agreement. I am a Moorish national sovereign. This court, as well as the people, have violated the Moroccan-American Treaty of Peace and Friendship of 28 June of 1786. Now, this quasi-contract that I presented to the courts, per the Michigan Supreme Court, the U.S. Supreme Court, this matter has already been litigated. And this court, as well as the people, are in default. And again, they refuse to give me their bond numbers, their names, and things of that nature so that I may properly file a lien in the federal court, as well as I'm preparing a 42 U.S.C. 1983 case. Again, the state has no duty to protect private citizens from private citizens under the Shaney versus Winnebago Department of Social Services 489 U.S. 189, 1989. If you go all the way back to the civil rights cases, the 13th and the 14th Amendments were created to protect African Americans from discrimination by city, county, and state and federal governments. And it also says in this case as well that they have no duty to protect private citizens from private citizens. So to compel performance of these corporate statutes, which it speaks about in Coins versus Virginia, again, 19 U.S. page 264, they created statutes to corporately punish the inhabitants of the city of Washington and the District of Columbia, and it went down into the other federal territories as well as the cities, counties, and the state governments. And they're committing fraud against the people. These these statutes that they have me charged with are unconstitutional. And I ask even though you're in default, I'm giving the state another chance, but this right here is already locked in. They're in default because the law says where they have a legal or moral duty to respond. Their silence is their acquiescence, their tacit agreement. So they're in default, Your Honor. And I would ask that the court subpoena Kim Worthy here so that we may put her on the stand to answer for her subordinates' criminal behavior as well as her criminal behavior. Have documents here where it's clear that they, can I sit down for a minute? My back is kind of bothering me. That's my leg shame. But I would like Kim Worthy to be brought in so that she can be questioned about the change in venue, the allegations, which are factual. But they sent me to prison for 15 years and 8 months for no crime at all. Judge Kirsten Frank Kelly was in Wayne County. She issued an order against me that was null and void. I was railroaded, sent to prison, did 15 years and 8 months where I lost my mother, family, time away from my daughter who's now 24 years old. She's a mother. I'm a grandfather. I've been productive in the community since I've been home. They're trying to make me look like I'm a demon. But the paperwork shows the opposite. And I would like all of these things. I would like an evidentiary hearing so that we may put these documents into evidence and that this case can be properly litigated. Because the prosecution is committing crimes. So I ask that this court use this subpoena power and adhere to their oath of Article 6, Section 2 of the U.S. Constitution, as well as Michigan Code of Judicial Conduct, Canon 2B. And the paperwork is clear. They refuse to respond. Everything that is happening now is criminal in violation of conspiracy, 18 U.S.C. 241, and in violations Michigan misconduct in office, MCL 750.505. I have been humble with this court. I haven't been here trying not to disrupt the court. I'm under threat, duress, and coercion. You know what I'm saying? They have constantly been retaliated against the Detroit police as the sheriffs, as well as Kim Worthy's office. And it's well documented. They sent me to prison off the testimony of a perjured witness. And I would like all these things to be adjudicated properly in this matter. And jurisdiction has been challenged per federal and state case law. The people have to prove jurisdiction. They have statements. The corpus delicti rule bars statements as hearsay out of court. And this is what they want, is they cannot make an affidavit for anyone. You see what I'm saying? My brother, as they claim, made these statements. I still haven't been given any discovery or anything. And they're in violation of the Michigan Court case law, Court of Appeals case law, and People versus Davey. This court clearly twice told me to give them discovery, 225 Michigan Appeal 502. And they're still violating the court's orders. And this court, honorable court, should exercise the contempt powers and have these officers supposedly acting for the court, which are being criminal, to be put in jail until they comply and or fined. Detroit police has a history. They were prosecuted by the Department of Justice in 2001. Then they were under the consent decree into 2013. And they're still committing atrocious criminal behavior and acts against natural persons, natural citizens. You know, Judge, you're familiar with this case law. You're a licensed attorney and an elected or appointed judge. I don't know. But the Supreme Court under Marbury versus Madison rulings, they're decisive, let the decision stand. This court is bound to adhere to Supreme Court rulings. These statutes in which they're charging me with are unconstitutional in violation of the civil rights cases, as well as Cohen versus Virginia, the Supreme Court. And today, again, I respectfully compel this court to adhere to these things. And the Supreme Court says where a court does not have jurisdiction to act, or where they don't have jurisdiction to refuse to act, it's considered treason against the U.S. Constitution, right? And the paperwork is clear. All parties that I've served these papers on are in default, Your Honor. And I ask that this court, like on page 30 13 and 14, I clearly stated in the offer, I'm the offerer, they're the offerees. And this process is approved by the Michigan Court of Appeals, Michigan Supreme Court, in which they cite federal court cases on the federal court cases, cite these cases as well. Give me a second, please. On page 13, it says, offerees 1 and 2 agree that all above and below statements are true, and they have until May 24, 2023 to admit or deny the above, and agree that terms, A, failure to hold state laws unconstitutional, and void ab initio, agrees to give me in the sum of $5,000 in gold and silver coins and or Federal Reserve notes and assets in their personal and official capacity. B, failure to dismiss charges with prejudice and grant all of the above, all of the supra and infra, agree to give me $500,000 and agree to be charged via MCL 750, 505, 18 USC 241, 18 USC 242 by the U.S. Attorney and the State's Attorney for their crimes via Turner Associates Inc. versus Small Parts Inc. 59 Federal Subsection 674 at page 680 through 82. Eastern District of Michigan, 1999, where they have a legal and moral duty to speak and agree that if they, offerees 1 and 2, try to impair this quasi-contract, argue or try to litigate this case further, instead of dismissal with prejudice, agree to give me $1 million in their individual capacity via Holland versus Earl Graves, Publishing Code 46, Federal Subsection 681 at 685 through 687, Eastern District of Michigan. Then there's affidavit of truth. I, Carnell M. McQuarrie Eel, says that the above is true and correct, and email these pleadings to offerees 1 and 2, which is Kim Worthy, as well as this court on May 10th of 2023, and I signed. The law is clear, Judge, and this court must enforce the law as written by the higher courts. This court is an administrative district court acting on a corporate level, and they cannot conflict, basically issue their rulings in conflict with federal Supreme Court ruling, which they have taken an oath to do so. If this honorable court refused to do so, it would be treason against the U.S. Constitution. And I ask that this case be dismissed at this juncture because statements, I have not been given anything by the prosecution and the people. And I would also ask that this court exercise the subpoena power and have Kim Worthy come here. She's not God. She's not a queen. She's not an empress or anything. She's an elected official. And her history precedes herself as committing crimes against citizens like Devontae Safford, Daryl Siggers, all these people that they're saying that they're trying to help get out of prison under the wrongful convictions unit. Valerie R. Newman was my former attorney, and that also makes it a conflict of interest because Judge Kirsten Frank Kelly heard her on appeal. She let the judge do it, and I had to do almost 16 years in prison for a crime where there was no legal jurisdiction at all. And there's documented evidence, paperwork, court seal, signature, and I'm being criminally retaliated against by the people. There's no way they can wiggle their way out of this. And I would like these things to be adjudicated and evidence. I would like an evidentiary hearing so we can admit evidence and or suppress evidence. I haven't been given discovery. I didn't even know I had court the first time I came. I had to go online and look it up. These are the games that they're playing. And I would like their oaths of office, their bonds, as well as other things. Because they're committing felonies, Your Honor. All due respect, and I like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court. The U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robinson. When he was in office many years ago, he did the right thing. They tried to get him to send young juveniles to prison. He said, no, these young men can be rehabilitated. And he sent them to juvenile prison. At this time, the prosecutor then went and attacked this judge. You see what I'm saying? You have a right and a duty to fulfill your constitutional oath, Your Honor, regardless of what they think about you or whatever else. These these statutes in which they're charging me with are unconstitutional. I never signed any agreements with the cities, counties, states, or whatever else to be governed by them, to adhere to their statutorily corporate statutes, which in Coins versus Virginia clearly states this is what the system is about. To create penitentiaries, to create prisons, hospitals, graveyards, streetlights, so on and so forth, in which today we live in this society. This society is clearly the matrix. The legal system is unconstitutional. These are corporate enterprises. They're no different than any other corporate enterprise when they provide services for the citizens. The case law clearly breaks it all down. I've never surrendered my sovereignty. Dred Scott versus Sanford clearly stated that blacks could not be citizens, were never intended to be citizens, and we were 3/4 of human beings. But under the democracy, pardon? 3/5, okay, 3/5. Under the democracy, which is nothing but the mob rule of the old South and European inhabitants of this country, if someone killed someone, stole something, they were all the mob who go out there and hang them and do whatever else. So every government is entitled to a Republican form of government. Not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. So I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing before we go any further. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCray did this, Mr. McCray did that, they come, then it's found out nothing happened. You see what I'm saying? Like, they even borrowed me from the Secretary of State because I was in there trying to conduct business. Oh, well, we got a call that you threatened somebody. Oh, we found out you're free to go, but they just don't want you in here. That's not how this government works. Or the so-called democracy in which you guys call it, but it's supposed to be a Republican form of government.
Okay, people have to respond.
Thank you, Your Honor. We're here because Mr. McCrary, the defendant, is charged with 10 felony counts. I've heard a lot of law quoted today. Everything from contract to treaties, corporate, but the only type of law that matters today is criminal law. And under our state constitution, this court has jurisdiction. Article 4, Section 15, the circuit court shall have original jurisdiction in the matters not prohibited by law, appellate jurisdiction from all inferior courts and tribunals except for otherwise provided by law, prior to issue here and determine prerogative remedial writs, supervisory and general control over inferior courts and tribunals within the respective jurisdictions in accordance with the rules of the Supreme Court and the jurisdiction of other cases and matters as provided by the rules of the Supreme Court. There's MCL section 767.1, several circuit courts of the state, the recorder's court, and any court of record having jurisdiction of criminal causes shall process